Good evening, everyone. And ask you to please take your seats. Get ready to start. Please remain standing for the playing of the national anthem of the Commonwealth of Dominica, which will be immediately followed by the opening prayer offered by Father Francis.
We begin this prayer in a special way, inviting the Trinitarian being, God the Father, God the Son, and God the Holy Spirit. In the name of the Father, and of the Son, and of the Holy Spirit, amen. God our Father, we just want to thank you in a special way for the gift of life, for the gift of one another, for the gift of this year, 2026, that you have blessed us with, O Lord. We bless your holy name. We thank you for your children, those who have been, in a special way, a gift to humanity in bringing peace, orderliness, justice, equity in our world. We bless your holy name for bringing them together to begin a new year. We ask, Lord, as we thank you for the journey mercy you granted to your children to be here, we thank you, and we ask you to bless them with good health of mind and body. Bless them with peace. Bless them with happiness. Bless them with joy. Bless them with wisdom. Bless them in a special way with that divine security and protection, especially in carrying out this great and wonderful duty you have entrusted to them. Lord, we ask in a special way that you bless us with your presence. Direct us. Send us your spirit as we begin this journey. Today, let your spirit bless every activity, bless this program, bless also in a special way all who come to participate. Bless our president, the president of Commonwealth of Dominica. Continue in a special way to bless her with good health of mind and body, and grant her success to the work of her hands. And in our noble country, Dominica, we ask you to bless her citizen. Bless in a special way our prime minister. Continue to bless him with wisdom, good health of mind and body, to continue to manage the affairs of this great nation. We make this prayer through Christ our Lord. Amen. Thank you.
Please be seated. Her Ladyship, the Honorable Madam Margaret Price Findley, Acting Chief Justice of the Eastern Caribbean Supreme Court, Honorable Justices of Appeal and High Court Judges of the Eastern Caribbean Supreme Court, Her Excellency Mrs. Josette Matthew, Acting President of the Commonwealth of Dominica, Dr. Irvin McIntyre, Deputy Prime Minister of Dominica, Her Ladyship, the Honorable Justice Wynant Roberts, and other retired judges of the Eastern Caribbean Supreme Court, the Honorable Levi A. Peter, Attorney General of Dominica, Ms. Sarah Lloyd, Acting Permanent Secretary of the Ministry of National Security and Legal Affairs, and Ms. Gloria Joseph, Permanent Secretary of the Ministry of Labor of the Commonwealth of Dominica. Her Honor, Ms. Gloria Augustus, Magistrate of Dominica, and other magistrates who may be present. Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Ms. Danelia Chambers Sylvester. Ms. Nerea Sebastian, Registrar and Ms. Kayan Tuse, Deputy Registrar of the High Court of Justice of Dominica, Mr. Francis Latang, Deputy Court Administrator of the Court's headquarters, Mr. Delano Bott, King's Counsel, President of the OECS Bar Association, Mrs. Noelise Naidije, President of the Dominica Bar Association, members of the bar, members of the clergy, Mr. Wayne Latang, Chief Fire Officer of Dominica, students, members of the media, specially invited guests. Good evening. I am Michelle John Thibbles, Chief Registrar of the Eastern Caribbean Supreme Court, and the pleasure has been given to me to be the moderator of this evening's lecture. I'm delighted to see so many of you here today. It is also heartwarming to see how many persons have gathered from across the region, have tuned in rather, to be a part of yet another milestone of the Eastern Caribbean Supreme Court. To those of you viewing online via the court's website, YouTube channel, and UWI TV, today's lecture is being broadcast live from the Nature Isle of the Commonwealth of Dominica. The island where my trusty Google app informs features 9 active volcanoes, numerous rivers, somewhere in the region of 365 in number, waterfalls, hot springs, and rainforests. Our precise location on this alluring island, however, is the State House Conference Center in the beautiful capital of Roseau. For the past 2 years, the Eastern Caribbean Supreme Court has been working on the mandate given by our immediate past acting Chief Justice to make the role, purpose, and workings of the court more visible and apparent to the citizens of the member states and territories that we serve. This would soon come to be known as the ECSC's Public Education Campaign. One integral component of this campaign has been the public lecture series. The first electrifying and, dare I say, technologically provoking lecture was delivered by the exuberant Attorney General of St. Kitts and Nevis, the Honorable Garth Wilkin, on the topic, Justice Without Borders, the Legal Practitioner's Perspective and the ECSC Reality. The second dynamic lecture, which focused on the topic, the court, ADR, and you, was quite aptly delivered by His Lordship, the Honorable Vashish Kokaram, Justice of Appeal of the Trinidad and Tobago Judiciary. The third impactful lecture focused on the impact of criminal court backlogs in the ECSC, transforming challenges into opportunities for change. And this was brought to us by an expert in the field, Ms. Shannon Jones-Gittins from the Antigua and Barbuda Bar. Today, we are honored to bring you the third lecture in the series under the theme, Estate Planning and Access to Justice. It is said that the only certainty in life is that we will die. While it is not a thought that many of us like to allow to take up much real estate in our minds, it is no doubt one of the more important things that we should have on our living to-do list. This evening, our lecturer will dispel some of the tabooism associated with this area, which will allow for a change in the mindset, which we all should have. And so, as we commence our proceedings, we are delighted to have the person charged with the responsibility of giving the official welcome. No, that was not me. Distinguished guests, I can think of no better person to bring the official welcome other than the Vice President of the Dominica Bar Association, Ms. Mary Oriel Roberts. Please make her welcome.
Thank you very much, Madam Chief Registrar. President of the Commonwealth of Dominica, Your Excellency, Mrs. Josette Matthew, Acting, Honorable Irvin McIntyre, Acting Prime Minister of the Commonwealth of Dominica, Your Ladyship, Honorable Madam Justice Margaret Price Findlay, Acting Chief Justice of the Eastern Caribbean Supreme Court, Justices of Appeal, High Court Judges, retired judges of the Eastern Caribbean Court, Honorable Justice Wynant Adrian Roberts, Justices of the High Court of the Commonwealth of Dominica, Honorable Levi Peter, Attorney General of the Commonwealth of Dominica, Honorable Ministers of Government, Permanent Secretaries, Your Honor, Mrs. Candia George Carrett George, Chief Magistrate and the other magistrates of the Commonwealth of Dominica, the DPP, Director of Public Prosecution, Ms. Shuma Dairample, Mrs. Tamika Burton, Solicitor General of the Commonwealth of Dominica, Chair, Mrs. Michelle John Thibbles, Chief Registrar of the OECS, the Eastern Caribbean Supreme Court, and the Deputy Chief Registrar, Nuraya Sebastian, Acting Registrar for our court, and Ms. Kayan Tousse, Acting Deputy Registrar, Registrar of Titles, Mrs. Vincia Auguste, OECS Bar President, King's Counsel, Delano Bartz, other members of the Bar Association, good evening. It is a true honor for me today to officially welcome you to this public education lecture, series of lectures at the invitation of our Chief Justice, which I understand to be promoting education for members of the public within our community being the Eastern Caribbean courts and the members thereof. Of course, I expect this lecture series not only to benefit the members within our community, but I dare say persons from outside of our community of the Eastern Caribbean. So I welcome you to this series. And of course, it's a true honor that Justice Honorable Alvin Pariaxin will be delivering to us on the topic which I think is timely and, as our chairperson said, something that we all need to know about: estate planning and access to justice. From previous presentations that I've attended that he has done, it has always been educational, insightful, and informative, and I look forward to this presentation to being just as exciting and informative, not only to us as members practicing at the bar, but also to the listening audience, who I'm sure will benefit tremendously from this presentation. We look forward to it. The Chief Registrar usurped my function as the Dominican here to welcome you to this State House and, of course, to the nature island of Dominica, where we boast not only of 9 volcanoes, but our bubbling lake, boiling lake, and, of course, on our numerous beautiful historic sites. Welcome to Dominica, to the Justices of Appeal. Some of you all may be here for the first time, or not so. Welcome to the listening audience to this interesting and what I'm sure will be an interesting presentation. Welcome to the listening audience on YouTube via all the social media avenues. And welcome to the press. And again, good evening, and do enjoy the evening. Welcome.
Thank you, Ms. Roberts, for your warm welcome. Our next speaker can be aptly described as the driving force behind and the person entrusted with the leadership of the court. Justice Margaret Price Findlay hails from the Twin Island Republic of Trinidad and Tobago. In 1985, her ladyship obtained her Bachelor of Laws degree from the University of the West Indies, and in 1987, her legal education certificate from the U Wooden Law School. Her ladyship immediately began her legal career thereafter, spending a number of years in private practice until 2009, when she accepted the call to serve in a higher capacity as a High Court judge. In 2022, Her Ladyship was elevated to the Court of Appeal, and on the 5th of May 2025, appointed to act as the 14th Chief Justice of the Eastern Caribbean Supreme Court. Ladies and gentlemen, distinguished guests, it is my pleasure to invite to the podium to give brief remarks Her Ladyship, the Honorable Madam Margaret Price Findley, Acting Chief Justice of the ECSC. Please make her welcome.
Good evening, everyone. I would like to adopt the protocol list already established. However, I would like to acknowledge the presence of the Justices of Appeal and Judges of the Eastern Caribbean Supreme Court, Her Excellency Ms. Josette Matthew, Acting President of Dominica, the Attorney General, the Honorable Levy A. Peters, and the other distinguished guests who are here this evening. And let me not forget, as I did this morning, the members of the Bar of Dominica. It is good to be here this evening for this public lecture series in the continuing effort of the court to educate the public and members of the bar and the profession. Earlier today, in my address to you for the Eastern Caribbean Supreme Court's opening of the law year, you would have heard me reference the court's deliberate efforts to increase transparency and bolster public trust through its public education program. This evening, it is my distinct pleasure to welcome you all to one of the many initiatives implemented under the campaign, the fourth installation of the ECSC's public lecture series. It is indeed fitting that the court should begin the new law year by giving concrete expression to its stated objectives, setting the tone for the priorities and principles that will guide its work in the year ahead. This lecture series is grounded in the belief that public trust in the justice system is cultivated when people understand the law, not as something distant or abstract, but as something relevant to their lived experiences. When the public is educated on areas of the law that affect families, livelihoods, and future security, they are better equipped to engage with the justice system more confidently and constructively. For that reason, the theme of this evening's lecture, Estate Planning and Access to Justice, is both timely and relevant. Estate planning is among the most empowering legal actions an individual can take. It allows us to exercise agency, clarity, and foresight over the disposition of our affairs, with effects that ripple past individual impact toward the future security and protection of our families. Estate planning is often misunderstood as being a concern for only the wealthy, who have sizable inheritances at play. Quite to the contrary, estate planning touches nearly every family in our societies. From planning the disposition of a modest home, savings, or a small parcel of land, to arranging the responsibility and care for those we leave behind, estate planning plays a crucial role in reducing the potential for conflict and distress at times of vulnerability. Too often are individuals and families introduced to estate law in moments of loss, confusion, or conflict that could have been avoided by prior planning. I am hopeful that tonight's lecture will greatly contribute towards breaking that cycle and inspire individuals to engage with the law proactively rather than defensively. From the court's perspective, estate planning is also deeply connected to access to justice. Empowering people to make sound legal arrangements for their future and that of their families significantly reduces the likelihood of costly litigation resulting from protracted disputes, which may lead to family feuds that linger long after the passing of a loved one. Indeed, the emotional and financial burdens that plague families when there is a lack of preparation of one's affairs parallels an increased strain on our justice system. By educating the public on estate planning, the court not only empowers individuals to act knowledgeably within the law, but also engages constructively in improving access to its own services and processes by fostering an informed and purposeful interaction with the justice system. This ultimately contributes to the reduction of the court's case backlog by minimizing the number of contentious probate matters. Access to justice is much more than making a legal process available to individuals to defend their rights. It is getting ahead of potential breaches by ensuring that individuals understand their rights and responsibilities and are able to take preventative steps to protect those rights and fulfill those responsibilities. And so, while estate planning is a private act, it is also an act of public good, both to the court and the wider society. Tonight's lecture is being delivered by the Honorable Justice Alvin Parry-Axing, High Court Judge, St. Lucia. Beyond the wealth of knowledge that he is poised to share with us, this lecture is especially valuable because it brings judicial insight directly to the public, being the first lecture in the series to be delivered by a judge of the ECSC. It reflects our belief that judges are not only arbiters of disputes, but also educators in the law. By sharing knowledge in forums such as this, the judiciary helps bridge the gap between legal principles and everyday life. In closing, I wish to thank Justice Parry-Axing for generously giving of his time, expertise, and judicial perspective toward the enrichment of the ECSC's public education lecture series. I wish also to extend sincere thanks to the dedicated management and staff of the ECSC who worked tirelessly to plan and deliver this lecture series, even while deeply engaged in the demanding preparations for this morning's opening. I offer special thanks to the ECSC Headquarters Information Technology team yet again, whose integral contributions and technical expertise were essential to bringing this lecture to fruition. I would also especially like to thank Mr. Dwayne Brissett, our Information Services Manager, who leads the planning and coordination of all our lecture series events. Your hard work, commitment, and professionalism are truly appreciated. As we listen this evening, I implore you to reflect not only on the technical aspects of estate planning, but also on the broader social implications. I am hopeful that the knowledge shared this evening will encourage thoughtful discourse on the theme, reduce avoidable conflict, and strengthen confidence in the justice system. I thank you all for your participation and continued interest in the work of the Eastern Caribbean Supreme Court, and wish you an enlightening and rewarding evening. Thank you.
Thank you, Madam Chief Justice. When deciding on the topics for the lectures in this series, we kept always at the forefront of our minds the purpose of the public education campaign. We therefore were always mindful that we needed to select topics that were relevant yet informative, important yet captivating, and appropriate yet exhilarating. This fourth lecture topic joins the 3 previous ones in this series to achieve this goal. To introduce the selected speaker, I would like to invite Ms. Kayan Toussaint, Acting Deputy Registrar of the Supreme Court of Dominica. After Ms. Toussaint's introduction, the next voice you will hear is that of our keynote speaker. Ms. Toussaint, please make her welcome.
Thank you very much, Chief Registrar. Good evening to everyone. Allow me to adopt the protocol list as established. It is my distinct pleasure to introduce our keynote speaker tonight, a jurist whose work reflects both legal excellence and a forward-looking approach to justice in the Caribbean. Justice Alvin Pariasing is an esteemed legal professional who holds a Bachelor's of Law from the University of London and a legal education certificate from Uilding Law School. He further honed his expertise with a master's degree in international commercial law, specializing in digital and cybersecurity law. Joining the court in May of 2021, Justice Pariasing has risen through the ranks, beginning as a master and now serving as a High Court judge. His contributions to the legal practice in the Caribbean are noteworthy. He has played a key role in the Caribbean Civil Court Practice 2024 and was a member of the Chief Justice's Rules Advisory Committee, which developed the Civil Procedure Rules of 2023. In 2023, he collaborated with Justice of Appeal Kukarang of the Judiciary of Trinidad and Tobago and former Chief Justice Dane Janice Pereira to introduce Judicial Settlement Conference. This innovative alternative dispute resolution method has achieved remarkable success, boasting a settlement rate exceeding 60%. As a result, this initiative was extended across all member states of the Eastern Caribbean Supreme Court and territories in 2024. With a wealth of experience in mediation, Justice Pariasing strongly advocates for alternative dispute resolution as a collaborative means to resolving disputes, promoting court adjudication only when truly necessary. Please join me in warmly welcoming our keynote speaker, Justice Alvin Pereira. Thank you.
This is fine. Do we have prize vehicles in front? Thank you very much, Ms. Toussaint. All protocols being observed. Good day, everyone, and thank you for joining me. Let me just move around this. Today's presentation is entitled Estate Planning and Access to Justice in the Eastern Caribbean Context. This topic may initially sound technical or even abstract, but in reality, it touches almost every family in our region. Estate planning is often treated as a private matter, something people will eventually get to. What I want to explore this afternoon is how estate planning also functions as a justice mechanism, one that can protect vulnerable family members, reduce conflict, and assist the courts in delivering fair outcomes. The purpose of this presentation is to explore the relationship between estate planning and access to justice. I will begin by clarifying what estate planning actually means, because it is often misunderstood. I will then examine the concept of access to justice, particularly as it relates to inheritance and family protection. From there, I will focus on the groups who stand to benefit the most from estate planning, especially common law spouses and children born out of wedlock. I will also look honestly at the limitations faced by the courts under intestacy law in parts of the Eastern Caribbean, and finally, I will discuss how estate planning and alternative dispute resolution can bridge those gaps. Estate planning is the process by which a person makes deliberate arrangements for the management and distribution of their property and affairs, both during their lifetime and after death. It is important to dispel the myth that estate planning is only for wealthy individuals. In reality, anyone who owns property, has dependents, or has people they care about has an estate. Estate planning is not about how much you have. It is about ensuring that whatever you do have is dealt with according to your wishes. At its core, estate planning is about intention and control. It allows the law to give effect to your intentions, rather than relying on assumptions or rigid statutory regimes. Estate planning can involve a range of legal tools, depending on the individual's circumstances. The most common and accessible tool used in the Eastern Caribbean is a will. A will allows a person who is known as the testator to specify how their estate should be distributed upon their death. Other tools exist, such as trusts, powers of attorney, and advanced medical directives, also form part of the broader estate plan. For the purposes of tonight, though, I will focus more on the will. Persons may choose to plan how property may be owned so as to exclude the property from forming part of their estate. For example, if a property is owned as joint tenants, where that concept exists, then the right of survivorship allows for the share of a joint owner to automatically pass to the other co-owners upon death. This contrasted with the concept of tenants in common, where there is no such right of survivorship. So, estate planning in one form may be simply severing a joint tenancy to ensure that your share as a joint tenant does not merge on your death with the co-owner's share in an act is one example, of estate planning. For most people in this region, however, as indicated before, a properly drafted will remains the cornerstone of effective estate planning. Estate planning matters because the absence of planning often creates confusion, conflict, and hardship for those left behind. These conflicts are oftentimes too far left for the resolution by the courts, usually after protracted litigation fraught with delay and costs. When a person dies without having made a will, families are unfortunately forced to navigate the legal system at a time of grief when emotions are already running high and oftentimes impairs reason and sometimes logic. Disputes may arise over property, relationships may deteriorate, and the court system becomes burdened with avoidable litigation. Estate planning helps prevent these outcomes by providing clarity, certainty, and clear direction. It is an act of responsibility towards those we leave behind. This brings me now to access to justice. Access to justice is a concept that goes far beyond access to a courtroom or court services. Many persons think that access to justice is simply being able to file a matter in court and getting a court date, but it goes way deeper than that. Access to justice refers to the ability of individuals to understand the law, to use legal processes effectively, and to obtain fair and timely outcomes. Importantly, access to justice also includes preventing injustice before it even arises. In the context of estate planning law, access to justice means that surviving family members are not unfairly excluded from inheritance due to technicalities, outdated laws, or the absence of planning. A useful and powerful illustration of what access to justice truly means is found in the case of Judge Daniel. And I will just tell you briefly what Judge Daniel was about. Case citation 2021 UK PC 31, Judge Daniel versus the Attorney General. That litigation arose because the halls of justice in Port of Spain lacked proper wheelchair access through the public's entrance. Mr. Daniel, a wheelchair user and disability rights advocate, challenged the state not providing wheelchair access to the High Court, asserting that this failure breached his constitutional right, inter alia claiming a breach of the right to access to justice. The Privy Council emphasized something that is central to today's theme. Access to justice cannot be reduced to the theoretical availability of the courts. If a person cannot enter a courthouse with dignity, cannot participate, cannot observe proceedings, or is forced into humiliating and roundabout alternatives, then the justice system, however principled in its doctrine, fails in practice. That case underscores that access to justice is not merely about formal rights. It is about meaningful, practical access. It is also about preventing injustice before it hardens into exclusion. In estate matters, access to justice is deeply connected with fairness and dignity. It means that modern family structures must be recognized and protected. It also means that courts must be able to deliver outcomes that reflect equity rather than being forced into rigid statutory results, especially where, as in most cases, the rules which govern intestacy are antiquated and oftentimes far disconnected from modern family structures in the Caribbean context. Where estate planning is absent, access to justice is often compromised, particularly for vulnerable family members. The parallels with the case of Judge Daniel matters as striking in one of context. The barrier is physical, in the other it may be statutory, evidential or structural, but the effect is similar. If a legal framework excludes a person who in all practical senses is a part of a family unit, then justice becomes contingent on categories rather than realities. To the extent to which judges can, they make decisions that reflect the lived realities of Caribbean people, but this is within limitations, which I will address later. Whilst the central objective of the justice system is to achieve fair outcomes of disputes, judges operate within the parameters of interpreting and applying the law that Parliament makes. Though in theory, judge-made law is a source of law, oftentimes the catalyst which judicial statements are meant to be for legislative changes fall on deaf ears. When this happens, not only is the litigant disenfranchised, but the court is unable to achieve its ultimate aim of justice. This is a severe limitation that the courts in the Eastern Caribbean face in estate matters, having to determine modern-day disputes in the modern family context using antiquated old laws. While estate planning benefits everyone, some groups benefit more because they are more legally vulnerable. These include primarily common law spouses and children born out of wedlock, whose relationships, depending on the jurisdiction, may not be fully recognized under intestacy laws. Estate planning gives the individual the ability to protect these groups intentionally and explicitly and bridges that gap. By way of illustration, of the modern family, based on the St. Lucia population and housing census undertaken in 2022, 16.6% persons 15 years and older are in common law relationships, and 11.8% of the surveyed population classify their union status as a visiting partner. This in contrast to 22.6% of the surveyed population being married. This survey was done throughout St. Lucia with a size sample of 139,510 persons. Across the Caribbean, the concept of the common law relationship has become quite commonplace. However, legislative changes has not followed that modern family development. Couples may live together in long-term committed relationships without formal marriage. They share homes, finances, responsibilities, yet under intestacy laws, in some jurisdictions, these relationships are invisible. When one partner dies without a will, the surviving partner may have no automatic right to inherit, regardless of the length or depth of that relationship. Estate planning provides a way to correct this injustice. Another example where legislative changes may be required can be found in the Civil Code of St. Lucia, which does not recognize common law relationships and prevents those who are in such relationships to be afforded similar entitlements to a legally married person. By way of contrast, however, in Trinidad and Tobago, the statutory framework developed by Section 25 of the Administration of Estates Act affords entitlements to cohabitants whose status as a cohabitant is subject to the Cohabitational Relationships Act. This provides the statutory structure for identifying and providing a cohabitational relationship, a cohabitational relationship, and for the court's power regarding property and maintenance once a relationship has been proven. It recognizes cohabitants as persons living together in a bona fide domestic basis outside of marriage, and it empowers the High Court to make adjustment orders in relation to property and, where appropriate, maintenance orders. The Act's prerequisites and remedial philosophy are important. It is not simply a symbolic recognition of the relationship. It is a scheme that allows the court to respond to contribution and dependency in a way that can prevent grave injustice. Of course, it is subject to the caveat that where the statutory conditions are satisfied. From the perspective of access to justice, this matters because it reduces the likelihood that a surviving partner is left with no remedy simply because the relationship was not formalized by marriage. Similarly, in April 2006, the Jamaican Parliament passed the Property Rights of Spouses Act, establishing a legal framework that broadens the definition of spouse. This law not only applies to married couples, but also recognizes common law relationships. For example, it treats a single woman who has lived with a single man for at least 5 years as if she were his wife. This comparative picture helps us to understand the broader point. Where legislatures have modernized family, property, and succession consequences, the law itself becomes less of a barrier to justice. Unfortunately, in the Eastern Caribbean, that legislative scheme does not feature. Where they have not, estate planning becomes the primary mechanism by which individuals can ensure that the people who function as family are treated as family. Children born out of wedlock face similar vulnerabilities. Although societal attitudes have evolved, some statutory regimes continue to distinguish between children based on marital status of their parents. This can result in evidentiary hurdles or delayed inheritance, and in some cases, exclusion altogether. Estate planning allows the testator to ensure that all children are treated equally and with dignity. In St. Lucia, by way of example, the Civil Code only allows for children of a single man or legitimate children of a marriage to be entitled to a share of the estate. It excludes children whose father at the time of their birth was considered a single man under the Civil Code, but who has subsequently married. An example of this is seen from the Court of Appeal decision of Cheryl Bertrand versus the Attorney General of St. Lucia, where the court addressed a legal challenge concerning the rights of inheritance of a child who was fathered by a married man in circumstances where the child's mother was not the father's wife. The claimant challenged the constitutionality of Article 579 of the Civil Code, asserting that the article deprived them of the right of succession, protection of the law, and equality of treatment, as well as breach of their father's freedom of expression. Ultimately, the challenge failed as the appellants were unable to show a connection between their father's enjoyment of freedom of expression and their ability to inherit from their father's estate on intestacy. Nor did the appellants establish that they had legal standing to pursue the claim in Section 6 of the Constitution. In conclusion, the law remains unchanged, which creates a special class of persons who would be unable to claim from their father's estate if he died intestate. In contrast, the Intestate Estates Act of Dominica, which I am grateful to Magistrate Gloria for bringing to my attention, provides a broad definition of child issue and child or other issue to include adopted children and illegitimate children, thereby allowing an entitlement to a share of the estate. This act therefore allows for protection of children who face similar vulnerabilities as seen in Cheryl Bertrand, who would have been entitled to a share of her father's estate had the claim been brought in Dominica. The point being that there is no harmonization of the laws of intestacy across member states and territories in the Eastern Caribbean. In Trinidad and Tobago, a useful point of comparison can be seen. The Distribution of Estates Act 2000 adopts an inclusive approach by defining issue in a manner that includes all lineal descendants whether born within or outside of marriage. The approach removes legitimacy as a barrier to inheritance. The access to justice significance is straightforward. Where the law does not force children into categories that reflect the marital status of their parents, fewer children are left outside the protective reach of intestacy rules. Where St. Lucia maintains distinction that excludes certain children, estate planning not only becomes prudent, but it becomes essential if equality among one's children is to be secured in practice. Estate planning protects vulnerable groups by removing ambiguity. By expressly naming beneficiaries in a will, a testator ensures that their intentions are clear and enforceable. This reduces the likelihood of disputes and prevents the law from imposing outcomes that may be inconsistent with modern family realities. The first practical step in estate planning is to have the intention to make a will disposing of your assets of your own free will in the manner that you want. Your capacity to make a will is something that may require certain medical examinations before you embark on that exercise, depending on several factors, including your age, any ailments, and certain other factors. Our Court of Appeal has given significant and detailed guidance on how the capacity of persons making wills should be treated to ensure that persons and their legal practitioners preparing wills are protected. And my reference is the Court of Appeal decision of Daisy and another versus Alcide, Court of Appeal number 30 of 2011, per Justice Mitchell, paragraphs 55 and 56, which I will not go into now. The second practical step in estate planning is identifying your assets. This includes real property, which is land, bank accounts, business investments, and personal belongings. Many people underestimate the importance of this step, but a clear understanding of one's estate is essential to effective planning. The next step is deciding who should benefit from your estate. This involves more than simply naming names. It includes deciding proportions, considering guardianships, taking care of minor children and persons with disability or vulnerable persons. It also involves making contingency plans in the case of a beneficiary that predeceases the testator. Clear decisions at this stage prevent confusion and litigation later. Estate planning should always be done with proper legal guidance. Statutory requirements for execution and witnesses of wills vary from jurisdiction to jurisdiction and must be strictly followed. Failure to comply can render a will invalid, forcing the estate back into intestacy, the very outcome the testator sought to avoid. One of the main benefits of a will is that it does not take effect until you die. It creates no proprietary rights, as it is only effectual upon death. This is important as the testator, the person making the will, can change it as often as you like until you die. Intestacy occurs when a person dies without a will. In such cases, the estate is distributed strictly according to statute, without regard to personal intention or family realities. These rules are often rigid and in some cases outdated. These rules vary from jurisdiction to jurisdiction, but the origin of these rules in most cases are similar models to the Administration of Estates Act of the United Kingdom of 1925, except for St. Lucia. The first incarnation of these rules are well over a century old. and has no regard for the modern family structure. Judges are bound by the law as enacted by Parliament. Even where a result appears unfair, the court cannot simply rewrite statute. This creates a situation where the court may recognize an injustice but lack the ability to correct it. This is what we mean when we say the court is handicapped. When this happens, the court usually suggests to the decision makers, Parliament, that changes to the law may be required to achieve just results. It is the duty of Parliament to change the law, but oftentimes we do not see that response to judicial decisions. In the Eastern Caribbean, these statutory constraints have real consequences. Common law spouses may be excluded entirely. Children born out of wedlock may face unnecessary hurdles or exclusion altogether. The result is increased and lengthy litigation, delayed distribution, financial burdens on the parties in litigating matters, and strained family relationships are commonplace when there is no proper estate planning. A properly drafted and executed will bridges the gap between rigid law and social reality. It allows individuals to bypass intestacy rules and give direct effect to their intentions. In doing so, if properly done, it assists the court by providing clarity and certainty. In essence, a well-crafted will effectively turns personal wishes into legally binding instructions. This not only safeguards one's legacy according to their desires, but it also provides the surviving family members with a sense of peace and assurance. Seen through these lenses, a will becomes more than a legal document. It is a tool of access to justice, preventing exclusion, protecting vulnerable persons, and promoting fairness without the need for litigation. Despite careful estate planning, disputes may still arise. Family dynamics, misunderstandings, or challenges to a will can still occur. When they do, alternative mechanisms become important. Alternative dispute resolution methods, such as mediation and judicial settlement conferences, offer less adversarial ways to resolve estate disputes. They allow parties to reach mutually acceptable solutions in a more flexible and humane setting in circumstances where the court's options may be truncated by existing antiquated legislation. ADR helps the court to temper the court's handicap. While it cannot change the law, it allows for negotiated outcomes that better reflect fairness and family realities, saving time, cost, and emotional strain to the parties. This may bridge the gap or cross the hurdles of litigation, but ADR is not a substitute for estate planning. It is reactive rather than preventative and depends on the willingness of parties to cooperate. Proper planning remains the most effective solution. The key message from today is simple but powerful. Estate planning is for everyone. Access to justice begins before conflict arises. Wills protect modern families, and without planning, the courts are often constrained in delivering justice which may be unjust. In conclusion, effective estate planning is essential for ensuring equitable access to justice within the Eastern Caribbean region. This process not only allows individuals to take charge of their financial and personal legacies, but also safeguards the well-being of vulnerable family members who depend on thoughtful provision during times of loss or transition. Moreover, robust estate planning facilities, the judicial system, by minimizing disputes and ambiguities over the distribution of assets, thereby promoting efficiency in the court system. In addition to these practical benefits, estate planning embodies a commitment to dignity, fairness, honoring individuals' wishes, and ensuring their intentions are respected even after they are gone. Rather than being seen as an optional endeavor for the wealthy or the elderly, estate planning should be embraced as a vital responsibility for everyone. This proactive approach not only secures the future of loved ones, but also strengthens community ties by fostering clarity and understanding during potentially distressing times. I trust you agree that estate planning is fundamental to the access of justice, as it ensures that the testator's wishes are respected without unnecessary court involvement, while promoting certainty and preserving the dignity of the modern family unit. My earnest hope is that this lecture prompts you to consider your own estate planning and to begin that exercise without further delay. I thank you for your attention.
We'd like to thank Justice Pariag Singh for that very thought-provoking lecture. Justice Pariag Singh, you had me sitting in my seat like, Please, let's give him another round of applause. We've come to the part of our lecture where we open the floor to receive any questions or comments from our listening audience. I'm not sure that we're able to receive from those who are viewing online. Mr. Brissett says no. But those of you who are here in person, if you have any questions for Justice Pariag Singh, we will take them at this time. You have another one? So Justice Pariag Singh, you can use this one.
Justice Pariag Singh. I don't think the Deputy Registrar had the right to change your name without your permission. So we'll acknowledge that. Just comments. Scenario. Foreigner marries a local. Okay, you catch me. I'm not from here. I think I'm of here now, but I'm not from here. Anyway, for convenience, to avoid when you purchase property, when you're married, the alien landholding license, etc., everything is put in the wife's name. She makes a will and gives everything to anyone else but the husband who survives her. So as you're talking about, that's her right, it's a testatrix's right. However, equity steps in. So what are your comments with regard to that as regards to, there might be a legal case with regard to the husband saying, wait a minute, you can't just throw me out. I know I built a doghouse, but I didn't expect I'd have to use it now.
Thank you, Mr. Murdoch. Before I answer you, Mr. Murdoch, a caveat that my Chief Justice has just indicated to me that we are not permitted to give evidence.
No, certainly.
Advice, and anything that I tell you is my opinion. It's not a reflection of the court's view.
Right. And that, I also predicated my thing with it's not going to be a legal
Yes, but
decision.
given your scenario, wouldn't the person who made contributions directly have an action in trust, which survives the disposition in the will? So it does not necessarily touch and concern the estate planning per se, but the person who feels that they are cheated can access the court services to assert their rights based on contributions, and that will be determined on trust principles.
Yeah, I was just asking for the benefit of others because my girlfriend asked me to ask that.
I hope your girlfriend was listening, Mr. Murdoch.
There's a lot of learning tonight, a lot of learning in our culture.
Any other questions or comments?
Sorry. Good evening, Dawn Yearwood Stewart here. I've listened attentively to your statements as it relates to estate planning. All well and good, but invariably, unless you do inter vivos dispositions, and even those are challenged, I think that you will always have problems with those who are dissatisfied one way or the other. That's one of the comments I wish to make, because it's your property, and you do what you want with your property, but then when you die, you see in all kind of pleadings, the testator told me, and he told me this, and he told me that, and this is what they want to rely on, and then ask the courts to believe them. Dead man tell no tales. So how then can, in those circumstances, I would say, well, let me say it differently. Estate planning can help, I agree, but then I don't know that it solves the problem of preventing disputes from arising, notwithstanding.
Thank you very much, Mrs. Yearwood Stewart. And I agree with you. It does not prevent disputes from arising. Certainly, in the context of my presentation, what I would say is that where persons believe that they are entitled to certain financial provisions from estates, there are legislative schemes, for example, in the UK, that provide specifically for applications to be made to the court, claiming whether the person died testate or intestate for financial benefits from the estate. We have no similar legislative framework, and perhaps that's an issue that the bar may wish to agitate about. That's one answer. The second aspect of your question, with respect to preventing disputes, disputes will always arise. The court always has the equitable jurisdiction to exercise as well. And judges, we do this every day in terms of what is fair, but that fairness is within the parameters that judges operate. It would assist the court if there was a statutory framework that says specifically if you fall within a class of persons, you may apply for financial provisions from an estate if you meet certain statutory criteria.
Good evening, Justice Pariat Singh. You spoke about the law, about the statute being archaic in certain instances. In Dominica, for example, you have a number of Muslim families.
Number of what, sorry?
Muslim families, yes, who have recognized households, but the law only recognizes one wife. But they have families and they get along just as if they're all recognized. The Muslim man dies intestate. But the law in Dominica, the Intestate Estates Act, would allow for all his children to be recognized. But his wives, who might have depended on him throughout his lifetime, what happens in a case like this? And is that a case where the equal access to justice is not provided?
Thank you very much, Mr. Lawrence. I have encountered a situation exactly with what you're speaking about, and Justice Amor would bear me out on this. In Trinidad, given the amendment to the Distribution of Estates Act, a cohabitant who you live with as in a bona fide husband and wife relationship for 5 years is given a portion of the estate together with the wife. So in the case of a Muslim marriage, where there are, or marriages, what usually happens is that the cohabitants, or the second, third, or fourth wife, would be required by statute to lodge a notice with the registrar indicating I claim an interest as a cohabitant. The court then allocates a portion of the estate that goes to wife. In Trinidad, that is 50%, I believe, Justice Amo. It's still 50%. And a judge of the High Court, within 3 months of submitting that notice, must then distribute that one half of the estate to the wives, after considering the evidence. So, in Trinidad at least, you may have a wife and a common law wife. They will share 50% that's allocated by statute to the wife. So, does that answer your question? Thank you. Have I gotten that correct, Justice Amo? Yes, just making sure. So, Mr. Lawrence, it just means the more wives that you have, the less they get. Yes, Mrs. Felix Evans.
Good night, everybody. Good night, Justice. I must say that it was a very excellent delivery. And I think it's more of a comment that I have for when we are looking at reviewing our laws and so on. Because while during your presentation, you would have recognized that based on our Intestate Estates Act, all children are equally entitled. In our Intestate Estates Act, we have a situation where a married man dies without a will, and his wife is only entitled to a life interest. And this can become problematic because while a wife may have met a husband with a plot of land, there was no house on it. They would have together built that home, and then she has a life interest, and other children and beneficiaries who would come after her comes in and enforces that right. That doesn't allow her to sell or be able to do whatever she pleases with the property. So in a situation like that, we see that our laws, it's revision and revising. So I just wanted to make that comment.
I agree with you. It may be that the statute may need some amendments or some tweaking, but it also gives rise to, again, a trust matter, because it's a matter of direct contribution.
Yeah, but sometimes some people don't want to go through that whole process of feeling like they're fighting other people, plus the expenses that comes with those types of matters as well. So if the law is revised, it makes it easier for a wife to be able to and assert her rights, as opposed to have to go and do all of this.
Perhaps you can also look at the St. Lucia model, where you can elect whether you wish the life interest or to cash in.
Yes, Justice. Thank you.
Good evening, everybody. Justice Periaxing, you did mention power of attorney as one of the instruments that can, estate planning. In Dominica, the concern is that we do not have durable power of attorney, or enduring, living, or durable, you call it. How do you see the enactment of that legislation assisting in estate planning and access to justice?
Can I just say that I have seen in Trinidad there is still the legislation that provides for the living power of attorney. But what often happens is that there's a conflict between the person who holds that power of attorney post the death and the person who is appointed executor or administrator. So it tends to be more problematic than effective. So although it exists, I have never actually seen it in practice. So I don't think it's a very effective legislation. So it's not something that I think that, I certainly think there requires some further investigations and studies as to whether or not that actually will have a practical benefit of having the living power of attorney.
Evening, Justice Periaxing, Madam Justice Price Findlay. I know you said you're not giving legal advice, so I would just want your opinion on what do you think is the court's role in estate planning as it relates to creating, well, according to the OECS, a will depository, one, and two, creating protocols or policies as it relates to doing mini mental tests or mental aptitude tests as relates to wills, because you find oftentimes the court is bogged down with litigation relating to whether or not the testator had mental fitness at the time.
Thank
so
you.
Those are my two questions.
In terms of the depository of wills, that is certainly requires statutory intervention. So I don't think that the court will have much of a role in that regard. But as it relates to the second aspect of your question, the What exactly was your concern? Well, in terms of the aptitude test, the court has no policy, but the decision that I referred to of Daisy and Alcide, it is the most detailed, comprehensive, step-by-step guide of the Court of Appeal as to what should be done whenever you have to prepare a will or any testamentary instrument for somebody who may be considered vulnerable because of age, infirmity, or even if you have a suspicion. I would commend that decision to have a read of it, and I think that after you read that, you would see that the guidance is so clear that there is no need for really having a policy. Daisy and Alcide. Thank you. I will give you the citation after.
We will take just one final question. Mr. Brissett, do you have the mic?
Okay. Good afternoon, or good night, sorry. I want to thank you for the presentation, but my question relates to a cultural situation where we have families, closely knit families, where everybody is involved in the decision making. The question comes is whether the will making an instruction for the will is only a matter for the owner of the property or whether it's a family decision.
Well, no, that is definitely a personal decision. It's not a family decision.
I don't know that we have a family will. Provision for a family will. Thank you. You have? Okay, I will allow you as the last.
Good evening. It's just a comment. I am quite aware of, in the Caribbean, of a lot of cases of caretakers of the elderly and common law spouses situation that people would say, or the general public might say, is unjust, right? What happened is that a lot of people think that when they tell you something, it has the strength or the force of law. And a lot of people, I'm not sure where this came from, think that if I make a will, I will die. Right? No, this happens. Or when they think they're going to die, they rush to make the will. So what we need in the Caribbean is that the public needs to be educated so that they can have strong advocacy for legislative changes. Because the law is really archaic. It needs to be reviewed. But the question is, who will do it? When will we do it? And also, we need to be able to learn from other countries that have, in some areas, particularly for the common law spouse, the common law spouse, to take these into consideration. So it's something that has to be done, that should be done, and once, because people always talk about it, you have a little meeting, they discuss it, and then it dies. What we need is consistency so that it can move up to the other level, to Parliament, so that things can change, because they are really archaic. That's my comment.
Thank you.
So until such time, what do? Make a will. Thank you very much. Thanks for your questions, your comments. Let's give Justice Pariagsing another round of applause. Thank you. I'll now invite Her Ladyship, the Honorable Madam Margaret Price Findlay, to present this gift to Justice Pariagsing.
I have no idea what it is, but it is very heavy.
Yeah, so we'll take it out. Justice Pariagsing, we can take it out.
The presentation. It was very enlightening, and we're glad that you took the time to assist me.
That's why I said we wanted to take it out of the box. Everybody wants to see, including the chief. What does it say? When the mic, please. Presented to the Honorable Justice Alvin Pariag Singh in recognition of your invaluable contribution as keynote speaker at the ECSC Public Education Lecture Series, Estate Planning and Access to Justice, from the Honorable Chief Justice, judges and staff of the ECSC headquarters, 12th January 2026. Thank you. It was William Arthur Ward who said that feeling gratitude and not expressing it is like wrapping a present and not giving it. So it would be unpardonable of us not to take a few moments to present our expressions of gratitude to the many persons who assisted and who worked so tirelessly in making this event the success that it has been. So to offer the vote of thanks, I would like to invite to the podium Ms. Nureya Sebastian, Acting Registrar of the Supreme Court of the Commonwealth of Dominica.
Good evening, everyone. Please allow me to adopt the protocol that has already been established. First and foremost, we extend our heartfelt gratitude to our distinguished Speaker, His Lordship, the Honorable Justice Alvin Pariag Singh, for delivering such an insightful and thought-provoking lecture on estate planning and access to justice. This is an area of law that affects each and every one of us, and I'm confident that all who have gathered here today will leave with a far deeper understanding of the subject and be better equipped to make informed and appropriate decisions regarding the planning of our estates. My takeaway: make a will. Protect our loved ones and minimize disputes, and seek legal advice. Permit me to also note that prior to His Lordship's elevation to the High Court bench, he served as master in Dominica, where he was always willing to guide, teach, and generously impart his knowledge to counsel and the staff of the Commonwealth of Dominica High Court. Although His Lordship is not assigned to Dominica, he continues to provide invaluable support to the Commonwealth of Dominica High Court, for which we are most grateful. I wish to express sincere thanks to the Honorable Chief Justice, as well as the management and staff of the Eastern Caribbean Supreme Court for organizing this important public lecture and your commitment to meeting with and educating the public on pertinent legal matters. Special thanks are extended to the IT department of the Eastern Caribbean Supreme Court for ensuring that all technical requirements were met and that the lecture was executed seamlessly. I also wish to thank Mr. Brissett for his role in the organization of this lecture. As our primary contact person, he provided us in Dominica with the necessary information to prepare for this event and was very instrumental in ensuring that the venue was set up appropriately. I further extend my gratitude to the Honorable Minister of National Security and Legal Affairs, Mr. Rayburn Blackmore, and the Acting Permanent Secretary in the Ministry of National Security and Legal Affairs, Ms. Cyril Lloyd, for the support extended to this event. We also wish to thank Her Excellency Sylvanie Burton, the President's Secretary, Ms. Donille Blackmore, Assistant Property Administrator at the Office of the President, Mr. Viret Sampson, and other members of staff at the Office of the President, who ensured that our experience at the State House Conference Center was both smooth and pleasant. Special thanks is also extended to Mr. Lester John Baptist, who ensured that the venue was beautifully prepared and welcoming. We acknowledge the dedication and support of the staff of the Commonwealth of Dominica High Court Registry, who worked diligently within a very short time frame to ensure that all necessary arrangements were made and in place for this lecture. Your efforts and commitment are both recognized and sincerely appreciated. I wish to thank Her Excellency Josette Matthew, Acting President of the Commonwealth of Dominica, for gracing this event with your presence. To our Court of Appeal and High Court judges, we thank you for your presence and your support to this lecture. To our young minds, our students who are present this evening, we thank you for being here and hope that you have gained valuable knowledge and insight from this experience. Finally, I would like to thank all participants and audience members locally and abroad for your active participation in this lecture. To everyone who contributed, either directly or indirectly, to the success of this lecture, we say thank you.
And so our time together has come to an end. I don't know about you, but I consider us all fortunate to have been a part of this lecture series here in the Commonwealth of Dominica, another pivotal milestone for the ECSC. It has been my esteemed pleasure to perform my duties as moderator here this evening, and as we bring the event to a close, all that remains is for me to thank each and every one of you across the length and breadth of the region for your attendance, whether in person or virtually, and for your continued commitment to the court. May we all look forward to many more milestones to come. For those of you who are here with us in person, we invite you to stay on for our cocktail reception. For those of you online, we'd like to thank you once again for joining. And have a drink on us. I thank you. At this time, I invite you to please be upstanding for the departure of Her Excellency, Mrs. Josette Matthew, Acting President of the Commonwealth of Dominica. Thank you for joining us. Thank you. Thank you all and have a pleasant evening.